Nanoco is involved in the research and development, licensing, and manufacturing of nanomaterials, with a particular focus on cadmium-free quantum dots. What are quantum dots, you ask, and why are they important? Simply, quantum dots are nano-sized particles that provide better color and saturation and range for the displays of electronic devices. Nanoco's quantum dots not only enhance the color of displays, but also more energy efficient too, when compared to LCD displays. Moreover, Nanoco's quantum dots are free of the cadmium chemical element, which may be a future value driver as the European Union is receiving calls and recommendations to limit or even ban cadmium in displays. What is exciting about Nanoco is that they potentially stand to benefit from a major lawsuit with Samsung, who are accused of infringing Nanoco's quantum dot intellectual property on a large scale. Nanoco collaborated with Samsung over a period of 4 to 5 years to help them solve this problem for their televisions. At the end of this period, however, instead of licensing Nanoco's technology, Samsung launched their own range of quantum dot televisions without an agreement for Nanoco's intellectual property. Nanoco being of the view that in doing so, Samsung is infringing on Nanoco's intellectual property rights. This has become the subject of litigation. If Nanoco emerges from this litigation battle with Samsung victorious, there could be some serious upside for its shareholders, with the CEO of Nanoco going as far to say that even modest success with the litigation would possibly result in multiples of the current market cap. So let's unpack the litigation. There are two concurrent processes. The first one involves the Patent Review and Appeal Board. This board decides which of Nanoco's patents are valid. This determination of validity is expected to happen in May 2022. The second process is before a court in Texas, and this determines whether Nanoco's valid patents, as decided by Process 1, have been infringed by Samsung. This is expected to take a week and take place towards the end of 2022. Nanoco has 47 different infringement claims against Samsung, and only one needs to succeed for them to win the trial. However, they can't explain all 47 infringement claims alongside their 5 patents to a jury within a single week. Consequently, Nanoco shall choose what they perceive to be their strongest claims out of the patents that the board in Process 1 determines to be valid, and put those before the jury in Process 2, which is the process before the court in Texas. By way of a timeline, on the 17th of February 2021, Nanoco filed a patent infringement lawsuit against Samsung in the U.S. District Court for the Eastern District of Texas. On the 26th of March 2021, there was a claim construction, aka a Markman hearing. Per Nanoco, a Markman hearing establishes the court's interpretation of certain words or phrases pertinent to the patents and the case. Nanoco and Samsung argued over the definition and meanings of 5 different keywords and terms in patents that Samsung have allegedly infringed. Nanoco won 4 out of 5 contested meanings. During May 2021, the Patent and Appeal Board has granted Samsung's request to examine the validity of Nanoco's patents in the case. During May 2022, the Patent Trial and Appeal Board shall decide on the validity of Nanoco's patents. And during October 2022, there shall be a trial expected to last 1 week in front of a jury about whether infringement of the patents has taken place. So, what potential upside is there? If the Markman hearing is anything to go by, where Nanoco won 4 out of 5 of the contested interpretations of the meanings of the patents, Nanoco's prospects of success are encouraging. If Samsung is judged to have infringed Nanoco's patent under one of the 47 claims, then they shall be liable to pay Nanoco damages. Damages would take into account all the historical sales of Samsung's quantum dot televisions in the United States, which accounts for about a third of their global sales. sales of quantum dot televisions, that is. Moreover, such a judgment would likely prompt Samsung to agree to a licensing or royalty agreement with Nanoco to use their technology in the future. Additionally, Samsung may compensate Nanoco for television sales it has made globally, not just in the United States. All of this would be in a bid to avoid future litigation with Nanoco in other jurisdictions. The quantum of damages would depend on the extent of the contribution of the alleged infringed patents to the television manufactured by Samsung as a whole, and their subsequent sale as determined by the court. The court could A. determine that the infringed patents are so fundamental to the television that it is the primary reason a buyer would purchase it, or B. that it is one component among many in the TV, but it is still nonetheless infringed. If the jury decides that Samsung infringed Nanoco's patents willfully, that is to say deliberately as opposed to mistakenly, then damages could be potentially multiplied by 3 times. However, it should be noted that Texan courts tend to only multiply damages by 1.2 to 1.5 in such circumstances. Samsung sells billions of pounds of sterling of TVs each year, so even a modest victory for Nanoco here could constitute a huge windfall given their market cap. This could result in a large appreciation in the share price of Nanoco. Please note that any award would be subject to UK corporation tax. Nanoco would get 50% of any outcome after payments to advisors, its litigation team and others. However, if the award is greater, for example because Samsung was found to have willfulness, Nanoco would retain around 80% of the damages. Now, let's take a look at the risks. As I see it, there are 3 primary risks. 1. Litigation costs. 2. Nanoco losing the litigation. And 3. Nanoco's cash burn. The first is easily addressed. The litigation is currently being underwritten by a third-party funder. This funder shall only get a return if Nanoco gets a successful outcome, whether negotiated, won through litigation, or otherwise. The second risk, Nanoco losing the litigation, is a possibility, and any investor should be cognizant of that, and all other risks before investing in Nanoco. The third, Nanoco's cash burn, requires a longer answer than the first 2. As of 2021 year-end, Nanoco had £3.8 million in free cash flow. The company's management is seeking to ensure that there is a sufficient cash runway to go beyond the key dates of the lawsuit in 2021. This was illustrated after Nanoco restructured its workforce in order to reduce its cost base to £400,000 per month. Nanoco shall also be vacating the first floor of their Manchester headquarters to save an additional £500,000 a year, with a view to identifying further cost savings where possible. With the current projected revenue, Nanoco expects to have £200,000 cash burn per month. However, if necessary, they are prepared to restructure the company into an IP shell with a £100,000 monthly cash burn so that they could continue with the litigation. In that scenario, Nanoco would likely no longer seek to derive revenues and continue research and development, but instead the focus would solely be on the litigation. Nanoco's board is of the view that it is undervalued, so refused to issue new shares earlier in 2021, instead opting to issue non-dilutive debt notes to its largest shareholders. This suggests that the board won't seek dilution unless it's necessary. This video is for informational purposes only. I am not a financial advisor. This is not financial advice. Do your own due diligence.